της σημερινής ημέρας, η οποία έχει ως γενικό τίτλο την Ανεξαρτησία της Δικαιοσύνης και το Ευρωπαϊκό Δίκαιο, το συγκριτικό παράδειγμα. Είναι ενδιαφέρον ότι φυσικά η δική μας έννομη τάξη, η οποία είναι ενταγμένη στην ενωσιακή έννομη τάξη, στην ευρωπαϊκή έννομη τάξη γενικότερα, να δέχεται οπωσδήποτε και κάποιες να έχει επιδράσεις από άλλες χώρες ή από τις εξελίξεις οι οποίες υπάρχουν στο ευρωπαϊκό δίκαιο γενικότερα. Έτσι λοιπόν έχουμε την χαρά να φιλοξενούμε και δύο κυρίες δικαστίνες από την Αυστρία και την Πολωνία, οι οποίες θα μας εισαγάγουν στο συγκριτικό αυτό παράδειγμα. Είναι η κυρία Edith Zeller, που είναι πρόεδρος της Ένωσης των Ευρωπαίων Διοικητικών Δικαστών και δικαστής στο Διοικητικό Δικαστήριο της Βιέννης, και η κυρία Καταρζίνα Γκάιντα Ροσινάσκα, λυπούμε πάρα πολύ που δεν μπορώ να προφέρω το όνομά της όπως θα έπρεπε, η οποία είναι από την Πολωνία, είναι δικαστής και παράλληλα επίκουρη καθηγήτρια στο Πανεπιστήμιο της Σιλεσίας, και η δική της παρουσία εδώ έχει μια ιδιαίτερη σημασία λόγω και των εξελίξεων τις οποίες έχουμε όλοι παρακολουθήσει, των αρνητικών και δυσάρεστων εξελίξεων που έχουμε παρακολουθήσει όλοι και οι οποίες αφορούν στις ρυθμίσεις σχετικά με την δικαστική εξουσία στην Πολωνία. Και έχουμε βεβαίως και την καθηγήτρια κυρία Πρεβεδούρου, η οποία θα ασχοληθεί με ένα ειδικό ζήτημα πολύ ενδιαφέρον, το οποίο έχει προκύψει και κυρίως από την ομολογία του Δικαστηρίου της Ευρωπαϊκής Ένωσης, αν έχω σωστά υπόψη μου, κυρία Πρεβεδούρου. Θα παρακαλούσα την κυρία Τσέλερ να ξεκινήσει με την δική της εισήγηση και υπάρχει δυνατότητα, υπάρχει αυτόματη διερμηνία για όποιον θα ήθελε να παρακολουθήσει τις εισηγήσεις που θα γίνουν στα αγγλικά. Ναι, ωραία. Κυρία Τσέλερ.
Thank you very much, Honorable Chair, esteemed speakers, dear colleagues, dear all. I'm very glad to be here, and first and foremost I want to thank the organizers for having organized this conference on this very important issue on independence. And as I've seen, it's in a very structured way, all different... Yes, I try to speak slow, as I'm usually speaking too fast, and especially I try to make it possible to give the translator possibility to be able to translate. So sorry in case I'm getting again too fast, please interrupt. Yes, thank you. So I want to thank the organizers for it, and I'm very happy to be here, because what I want to start with is, what is a job profiling for a judge? What does a judge have to do in principle? Grant fairness in proceedings, be impartial to the parties to the case, find a solution in a dispute of two parties in a highly qualitative manner, and also to be as speedy as possible, so to say it in a nutshell. Out of these duties of a judge, for sure, it's combined with a specific status a judge must have in order to fulfill this job profile. With these duties, certain responsibilities go hand in hand, and based on the responsibilities, accountabilities. The specific status is also necessary for granting independence. Independence of the individual judge, as well as structural independence of judiciary as such. By this, to guarantee this specific status, a judge must have. Correlating with independence is the responsibility issue and accountability issue. Responsibilities and accountability of a judge is also relevant because in the final end, what judiciary must get is the trust of society. Otherwise, there will be an independent judiciary will be eroded in the final end, and democracy with it finally. Therefore, it's also relevant that judges are responsible and accountable. First, therefore, I also want to address issues of responsibility because it's combined with independence. Responsibilities of judges, the legal basis is in European soft law standards, like the recommendation of the Council of Europe 2010-12, CCJE opinions, but also in each of our constitutions, as well as for sure Article 6 and Article 6 of the Convention, and Article 47 of the Fundamental Rights Charter, as well as EU constitutional law. Accountabilities can only arise on the basis of responsibility. Responsibility of a judge is not only to adjudicate correctly in the cases, but it's also a responsibility of the judge to protect and to defend the rule of law. Because we are the third state power, so to say, every judge has this responsibility. Therefore, I want to give only some examples for responsibility pinned down on the basis of some benchmarks, what you call rule of law. For rule of law, there are certain benchmarks, and I want to give only some examples of responsibilities of judges on the basis of these rule of law benchmarks. One benchmark for the rule of law is principle of legality, which means supremacy of law everywhere. For a single judge, out of this benchmark, for sure, duty arises to give qualitative decisions based on the law, also the responsibility to use discretion in a proper manner in case discretion can be or must be executed by the judge, and also to give interpretation to unclear provisions in a proper manner with interpretation mechanisms. And it's also, for instance, an obligation for us judges to write a clear and transparent language out of this legality benchmark. Another benchmark for the rule of law is legal certainty. Here I want to mention the duty and the special obligation of Supreme Courts, because it's their obligation to look for a uniform application of law. They have specific obligations in this regard, because only through this it is predictable for the people, for the citizens, and legal certainty arises out of this. From the principle of effectiveness, for sure, it is the obligation of a judge to give judgment in a reasonable time. However, I want to stress in this respect specifically also the responsibility of judicial administrators and organizational parts of justice, because again, it's an issue of budget. When you do not have enough resources, you cannot give judgments in reasonable time. And a benchmark for the rule of law, as we know, is access to justice, to independent courts. Now we come to the independent courts from the perspective of responsibilities. When you have this benchmark of access to justice, I want to just to mention that it's also our obligation to look for appearance of independence, impartiality, which is relevant, and appearance of independence, integrity and ethics. We could talk about all many things for hours and days, just to be mentioned from the responsibility side. And as I've said, on the basis of these responsibilities and many other responsibilities, accountability can arise. It again, it's another issue which it's not time for it to talk about to whom a judge can be accountable for what and in which way. For instance, Mr. Puigdemont has sued now in Belgium a Spanish colleague from the Spanish Supreme Court for a judicial decision he has made. Obviously in Belgium it's possible, not so in other countries. Or in Romania, for instance, it was a big issue. Now they seem to have found in this respect a solution concerning that the judge is accountable for judicial errors. I think as long as a judicial decision is justifiable, accountability should not take place. It's mainly an issue of when there is legal error, there should be a possibility of appeal to another court. But anyway, accountability can be in formal proceedings, and it is also important, as what I have said in the beginning, that accountability must also be perceived by the citizens. For this, again, it must be transparent for the citizens. This is what is relevant for these responsibilities and accountability. It should all be here and is relevant, but it can only take place when there is full independence of the judges and of the justice system as such. And only on the basis of this, accountability can arise. And it's also important that the legislator and the executive power have trust in society and do not manipulate or do not speak against judiciary. And this brings me to some practical statements. What is it, from the very practical point of view, what are possible access points to infringe independence? It is highly relevant, and I'm very glad the Polish colleague is here, Kate, today, but it is also relevant to shed light on each of our systems which are not in the spotlight right now. Like in every system has strengths and every system has weaknesses. And in many areas, every system has kind of things which are not white, not really best practice, but still okay. So a bit gray, if you want to say it in colors. And when there are more and more gray areas in an organizational system, this might be still okay. But at a certain point, there is a highly danger that all this gets black, especially if let me say it very easygoing, if the players in that game don't rely to certain values anymore. And therefore, it is of real utmost importance to be aware of the problems which we all have in our systems and to shed light on it as well. From talking with many colleagues and from personal experience, there are specific issues which are sensitive and out of which infringement of independence can arise easily. Usually, systemic problems arise and emerge step by step. One issue which is sensitive issue is disciplinary legal regimes. As far as I know, also from the European community, in the final end, what European standards say, usually there is an independent tribunal deciding on disciplinary charges against judges. However, what is not clearly regulated by European standards and is sometimes not clearly regulated in each of our national systems, or easily to speak about the Austrian system, is what is with the preliminary phase? What is with the phase to start an investigation, to start disciplinary investigations against a judge until you come to the independent tribunal in this time? Problems can arise when a procedure is not regulated in detail by the national law and when you do not have protection mechanisms in this first phase. And when also, for instance, the substantive law, what exactly is possible disciplinary misbehavior is not clearly regulated in the provisions. When you have these gray areas, so to say, that you do not have regulations for the preliminary phase of a disciplinary proceedings, this is also probably not really an infringement. Because in the end you have an independent tribunal. However, if in the system there are other weaknesses, it can easily change. Like for instance, what in Poland has been the case that court presidents have been now selected and appointed politically, or is even the case in Austria, by Austrian constitution, to have politically selected and politically appointed presidents of administrative courts. Because court presidents, and I'll come back to this later, have always a relevant role to play. So when there are certain weaknesses, also this disciplinary mechanism can easily turn out to be not okay anymore, and can result in an undue pressure on judges, because in this phase, when there is investigation, this does something with the judge. The judge is under pressure, and in some cases, formally or informally, for instance, this judge can easily be prevented from promotion, etc. So it is a sensitive issue I want to mention. The next issue of possible access point for infringement of independence is the measuring. Measuring is tendency all over the systems, measuring justice. Measuring the quality of justice is really difficult, because also at least in the administrative judiciary, the systems are very different, but there's a tendency to count only numbers. Counting and statistics is also very fashion, but simply to count numbers is a simple productivity, and this is no longer high quality judiciary. This cannot be the case. And in case there is too much concern put on measuring numbers, this is also an undue pressure, because this can be a starting point for disciplinary proceedings, etc., a lack of promotion. So it's a clear problem, because it's impossible to compare cases simply by numbers. There's different complexity of cases, and it is also impossible to compare within Europe the numbers, because you have different systems, different procedural systems, so it's really not a good issue. And I want to highlight it because there's more and more tendency towards it. And also here, sure, also for this measuring and for the numbers, sure, there is a responsibility of a judge and of the judiciary system as well, but only on the basis of full independence, and then only then you have an efficient judicial system. Other examples for possible access points to infringe independence is career development. It's an issue not talked too much about by colleagues, but it's clear that career development must not be dependent on external pressure. It's on the one hand side, concerning career development, on the one hand side, external influence, there shouldn't be external influence, but there are systems like participation rights. I personally, I am asking myself, why do I need the participation rights of the parliament, whatever. But if it's only a participation right, it's okay. But there is a slight problem that this participation right could easily be an influence and influencing. And for sure, speaking for the administrative judiciary, for sure the executive power has an interest which judge makes career or not. I mean, sure. So it's important to have safety locks to make sure, okay, checks and balances are okay. Participation right, yes, but as minimum as possible. Concerning internal influence and career development, this is also a possible point of infringement of individual independence. It is relevant to have the evaluation of judges. In those systems, when you have a formal evaluation, there are some systems do not have evaluation, some do have informal evaluation, but most have formal evaluation, that the formal evaluation is correct. And it is relevant, the evaluation, for not only for career, but also to start disciplinary proceedings. So evaluation is always an issue. And again, here, let me mention the important role which usually court presidents do have. Court presidents or inspector judges, which there should be no influence from outside. This is really important. This brings me what I want to say also as a possible access point for infringement: court presidents. in many areas of judicial administration, which system ever it is, be it with a judicial council or with not, they have an important role to play. I'm very glad that there is a clear European opinion for European standard from CCJE, the Council of Europe, on the role of court presidents. They are the safety locks, they are the link to the other state powers, and they are kind of safety lock, one of the safety locks for the individual independence of the judges of the court. When you have court presidents who are selected and appointed politically, this is a real problem, or a strong weakness. Let's put it that way. It's really gray. And there's a danger when there are other weaknesses that it can turn easily to be an infringement. Another issue is the transfer of judges. Usually we have regulations in cases transfer is possible. There's also standards. It is important that the criteria are determined by law very carefully and very detailed in order not to make arbitrary transfers possible. Transfer of a judge, I immediately think of the next issue, often joined with the transfer, is judicial reforms. Judicial reforms is always a sensitive phase in every judiciary, and with it, transfer is made possible, easier, going hand in hand with judicial reforms. I understand that judicial reforms are important, and sometimes you have to adapt and do it. However, a judicial reform must not be abused to get rid of judges. I also understand that when there are systemic problems, is a judicial reform necessary? For instance, when it's a corruption issue, what is now at stake in some of European countries. But it is easy to abuse it. So first you defame judges and judiciary, say all are corrupt or all are I don't know what. And then on the basis of defamation, there is no public trust anymore, and then you can easily say, yes, now we must do something to wash away corruption, and we must do a judicial reform. And easy going with it, you get rid of judges you don't like, because it's important. I personally don't really understand, except there are exceptions, sure, but I don't understand with this corruption automatically to have judicial reforms, because usually we have disciplinary proceedings against judges, we have criminal proceedings against judges, and for sure corruption has no way whatsoever within judiciary. But in these proceedings it would also be good because both sides who are involved in this corruption deal would be transparent. And it's not good when this is just not done, but it's just judicial reform. The assignment of cases is usually, what I also hear from colleagues, usually the formal system to assign cases is usually okay. But there is, for instance, I know problems can arise that, for instance, a judge judging asylum in a way which is too much in line with European law, EU law, then suddenly, oh no, the judge must do not taxation law. For instance, this happens. And that's a danger. That's an infringement of independence when it's done because of, to avoid that the judges adjudicates in asylum matters, for instance. So the change of specialization, for instance, again, it's relevant to have protection standards, and again, also here, court presidents play also a role. Judicial administration, as we all know, it's really important. It can infringe independence when there is not enough budget. Budgetary means and to grant budget to judiciary in an adequate way is really important. Therefore, it's also relevant to have the highest amount possible to have highest amount of self-administration, what is possible for this judicial administration issues, including finance. And again, court presidents play a crucial role in this respect. I want to just give an example of what I heard from Italian colleagues is when some years ago, the Berlusconi Berlusconi trials were at stake. Suddenly, there was no physical personal protection, security for the judges, budget. Judges had to share a computer. 3 judges share a computer. Oh, it's a budgetary reason. So it's easy to infringe. Or for instance, in other countries, I have heard that, well, the courts have been closed, but officially because of budgetary reasons, but unofficially I heard that it was not liked how the judges adjudicate. Yes. Or for instance, when no replacement of vacancies of judicial posts is done, but it's only pressure put on the judges to solve more and more cases. Another access point for infringement of independence is influence peddling. I think this is an issue in our judicial work now, which is of gaining importance. Influence peddling is you want to get the decision as a party to the case, the decision you want, you like from the judge, which means it is important to promote your arguments. Litigation PR, litigation promotion. There are companies doing litigation PR. They are specialized in doing so, which means they make kind of marketing of their client, marketing, advertisements, interviews in newspapers, etc. When there is an important issue, so the marketing. And with this marketing, what to say, the rating of this client is improving. And for sure, every judge is also a person and is not shut up from society, so it's easy to influence. And there are also companies starting to work to psychologically check the judge. You're a big company, you want to have a big airport opened, whatever. And so it's a real interest. And these companies start saying, aha, this is my judge. So they start to check psychologically from, I don't know, social media, from the way the writing of the judge is, to address correctly and psychologically in the right manner the judge, to influence insofar psychologically the judge to give the judgment they like. So, and I think these issues with this influencing is increasing, especially also that digitalization in this respect makes it easier and should be addressed more carefully. So the manipulation issue. It's also the public opinion, which can be an access point for infringement of independence. Public opinion, there's a trend in the public opinion, there's a certain trend in the media to simplify things. A certain trend because it's important or it's not important, whatever. But it's a fact everywhere. I think the influence on or possible infringements by public opinion, we have to divert. There's public opinion influencing, see it differently when you have final judgments in pending proceedings and against judges and judiciary. When there is some kind of public opinion, like they write that they don't like the judgment made in a certain case. For instance, you have an asylum seeker, Austrian case, asylum seeker who has sexually harassed someone. But this asylum seeker was a minor, and for sure the law says when minors are criminally convicted, it's half of the amount of possible punishment. But the public opinion said, how can you do whatever? So it's a kind of influence. When it's a final judgment, I think, my personal opinion is that the judges must stand certain criticism, as long as this criticism does not undermine public confidence in judiciary as such. Because once public confidence is undermined, you don't have trust anymore. And for sure that the newspapers or the media is not always very objective. But so I think the lack of objectivity must be tolerated in a higher amount than concerning pending proceedings. When there is a public media acts in pending proceedings, I think this is a sensitive issue, especially in criminal cases, and should be realized by the judge but you cannot change it. And it might have effects also when the judgment has been given. It might affect future cases as well. So it's a problem. Also the criticism against judges as such, as persons, and judiciary as such, sure, it's okay to criticize, but as long as the public confidence is not undermined. What was in all newspapers when the British colleagues have decided on the Brexit, that the parliament must agree, like enemy of the nation, and on public and making public personal issues of a judge. This is definitely no longer okay. To write in Poland, that judges are judicial guild, or to say, as I think it was the Prime Minister or the Minister of Justice in Poland, I know everyone knows someone who has been hurt by judiciary. This is not okay. Or in Austria, for instance, when the governors of the provinces say, well, the decision on the third runway of the biggest airport, we don't like it, therefore the judges should no longer be able to decide in these areas of law. This is not okay. And this is really out of any justification of criticism. And there I think also we judges must be sensitive, because it's not for us, it's for the trust of society. Yes, and to sum up, I could talk for hours, even longer, but to sum up is we need mechanisms and protection shields. In every system we must take care, even if our system is not in the crisis, but we must be aware of the need that we must have protection shields of the independence, because only by this we can accomplish the rule of law and democratic state. And yes, we have to ask for enough safety locks. Thank you very much.
Ευχαριστούμε πολύ την κυρία Zeller για τις παρατηρήσεις της, οι οποίες αποδεικνύουν ότι υπάρχουν αρκετά κοινά σημεία με αυτά τα οποία εθίγησαν χθες και σήμερα στο πλαίσιο των εισηγήσεων για το ελληνικό σύστημα. Σε τελική ανάλυση, τα συστήματα, τα δικαιοδοτικά και τα προβλήματα τα οποία αντιμετωπίζουν δεν είναι πολύ διαφορετικά το ένα από το άλλο. Τώρα παρακαλούμε την Πολωνή συνάδελφο, η οποία είδα ότι πήγε και στο βήμα, να λάβει το λόγο.
Hello. First of all, I would like to thank the organizers for this seminar for their invitation to participate in this conference. It's a pleasure and honor. Thank you very much. And I would like to start with a short film, The Voice of Polish Lawyers.
Dear listeners and viewers from all over the world,
the purpose of this film
is to express our objection
to what is currently happening in Poland.
This is a voice of Polish lawyers of various professions.
Advocates, judges, attorneys, prosecutors,
university professors and students like me.
Our common democratic home is being
dismantled by those at power,
piece by piece,
in breach of our constitution
and the rule of law in Poland.
Our civil and human rights are being threatened.
The lack of constitutional protection,
because our constitutional tribunal is paralyzed, means that it is now
possible to pass any law by the ruling majority.
Even the most irresponsible and the most unwise law,
such as Holocaust bill.
We disagree with the interference with our
constitutional tribunal, which has become politically dependent.
We disagree with the unification of the role
of the Prosecutor General and the Minister of Justice,
leading to political influence on the prosecution of people who oppose the government.
It leads to political influence on the prosecution of people, like in communist era.
We disagree with the devastation
of the judicial system
and its independence.
With Minister of Justice nominees appointed as presidents of the courts, people with no experience or stature.
A democratic system cannot force a judge to be dependent on the prosecutor.
We disagree with the political takeover of the National Judiciary Council.
Its current members were ousted
before the end of their terms
and are to be replaced by 15 judges associated with the Prosecutor General.
We disagree with the devastation of the Supreme Court, with the immediate dismissal
of almost half of the Supreme Court judges being forced into retirement at the age of 65.
Including the President of a court before the end of her 6 years constitutional term of office. We disagree with the political dependence of the Supreme Court chamber
responsible for election control.
This is the end of our stable democratic system.
We disagree with the new election rules making election clerks
dependent on the ruling party and allowing elections to be falsified.
We disagree with the political takeover of the national media.
Has turned into a government propaganda machine.
We disagree with the laws allowing the government to invigilate
citizens without due case and court control.
We disagree with the government's offensive attacks on the European Union.
Poles are both Polish and EU citizens.
Europe is our home, and EU institutions are also our institutions.
We disagree with the government's attitude to the refugee crisis
and the lack of solidarity with those EU members who are helping.
Our solidarity heritage is being called into question.
We disagree
with restriction of women's rights.
We disagree with the devastation of our environment, blocking green energy solutions,
cutting the last primeval Białowieża forest with breach of EU law.
We disagree with the history politics,
including politically driven changes of museum exhibitions and the falsification of history.
We disagree with the so-called Holocaust bill.
This law restricts basic democratic values,
such as the freedom of debate.
We are proud of many aspects of our history,
but we are also aware of the dark sides.
And who is to judge this law now?
A politically dependent constitutional tribunal?
This film was prepared by Free Courts organization. It's a non-governmental organization with cooperation of solicitors, attorneys, notaries, professors of law, and of course judges. This is the voice of Polish lawyers. Let me start. I'm a judge. I'm not barrister, solicitor, and also a lawyer. I'm also assistant professor at Silesia University. And I would like to start my lecture with the words of the former Polish president of Supreme Court. What is independence? Justice is the basis of the states, and impartial justice can be only imparted to the judges who are truly independent. The independence of judges does not exist when it's provided by law on the paper, but only when the whole set of conditions in which the judge works consists in a guarantee of true independence. When the judge is in the general state hierarchy so placed that nothing from the government doesn't he expects, and is not afraid of anything, that he can quietly, without any personal risk, sentence, as he is told by the law and conscience. We can say today that in Poland, unfortunately, not everyone understood this principle. Of course, the autonomy and independence of the judiciary has always been perceived as a necessary and fundamental condition for the proper functioning by the system of justice. The autonomy of courts and its independence of judges with simultaneous administrative oversights by the executive branch have for many years been one of the most sensitive problems of the judiciary. Not only of Polish judiciary, but in judiciary and European countries. I try to discuss the process of dismantling of the free courts in Poland. Two preliminary remarks are necessary in this lecture. The first remark pertains to the fact that although I will be discuss only exclusively the organization of the changes in judiciary and its impact on the judge position and procedure in Poland, I have to speak about regulation according to the Constitutional Tribunal, to the National Council of Judiciary, to the Supreme Court, and also to the common courts. Amendment to this law without amending the Constitution, I mean to the Constitutional Tribunal, to the National Council of Judiciary, and the Supreme Court, and also the common courts, have a direct impact on the independence of courts as adjudicating bodies, while changing the political system of the state. In particular, the changes with respect of the law on the organization of common courts and the act of the Supreme Court, as well as an act of the National School of Judiciary and the public prosecution, create a concept of new judge dependent on political authorities by design. This is done by the way of modifying existing principles for taking and holding the office of a judge. The principles of professional advancement, retirement, disciplinary procedures, as well as the distribution of the competences with respect to organization aspect of the work of courts and judges. And I would like to start with EU perspective, because from our point of view, I mean from point of view of Polish lawyers, I must say that today without EU we have authority system today. I would like to start with judgment of Court of Justice dated on 27th February this year in the case Asociados Sindigas, or if my colleague wants to speak about this judgment, I can, yeah? Okay, so I can, I would like to say only one thing, that from the Polish point of view, this judgment is very important. Why? Without details, maybe, what this judgment means to Polish situation. This judgment into Polish situations means that contrary to the certain arguments raised in Polish public debate, the Court of Justice clearly recognized that EU law has and EU tribunal has clear competences based on the treaty to evaluate functioning of the judiciary in European member states, and in particular to evaluate whether the body in light of applicable regulation is a court in understanding of European law. It's a general concept that can be used, and general mechanism that can be used to any country of European law. And being honest, we hope that this mechanism will be used in Polish cases. So, Polish regulations and changes in Polish legal order. According to our situation, the foundations of the judiciary of the Republic of Poland are anchored in the Constitution. The network of the courts has been specified in Constitution. It consists of the Supreme Court, common courts, military courts, and administrative courts. The detailed rules of the organization of the judiciary and their internal organization structure have been left for regulation by statutes. Statutes are passed by ordinary majority in parliament. The Polish constitution, however, introduced a ban on creating extraordinary courts or on introducing ad hoc proceedings before the courts. But the Polish constitution permit to regulate the court organization by the statutes. It also confirms a constitutional rank to the right of each individual right to a fair and public hearing of his or her case without undue delay before a competent, impartial and independent court. In the Polish legal system, there is a presumption of the competence of common courts. These courts have jurisdiction in all cases except of those which have been expressly reserved for administrative or military courts. On the other hand, the different courts remain structurally dependent on each other. The principle of judicial independence of judges in Polish legal system directly becomes from constitution and representatives of doctrines recognize it as one of foundations of Polish justice systems. In Poland, we say that in practice, the independence of judiciary and judicial independence of judges are directly shaped by principles of appointing judges, principles of promoting and delegating judges, also the principles of responsibility to judges, principles of internal and external administrative supervision, as well as judiciary supervision, regulations and competences of judicial self-government, and principles pertaining to court administration. As it's commonly known, the recent years have been a time of very intense transformation in the system of justice in Poland. The reforms, which first touched the Constitutional Tribunal, then prosecution, then common courts, and finally National Council of Judiciary and Supreme Court, have been justified by the general ineffectiveness of system of justice and lack of public trust in the system. All of these arguments were used by government as legitimizing the changes enforced in the system of justice. These changes have to a great extent related to actually the manner and the scope of regulation of the competence of the Minister of Justice. The President the present scope of the regulation and the competence of the Minister of Justice in the system of law creates in consequence a rather complicated assembly and competences bestowed of this body in reference to the bodies of the judicial system. But let's start from the beginning. As it follows to this lecture on how to dismantle a democratic rule of law, the first was eliminated the Constitutional Tribunal. Against the law, the ruling of our Constitutional Tribunal were not published 2016, they were published 2 years later after the statement of the European Commission, and it was done with the violation of the Article 24 of the law of the Constitutional Tribunal. The President refused to take the oath from the judges that have been elected properly and were thus not allowed to adjudicate. So, starting from the beginning, our problem with Constitutional Tribunal is that we have judges that were elected properly and they cannot adjudicate because the President of the Republic of Poland decided not to take the oath from them, and the same, I mean the lower chamber of the Polish Parliament elected other judges in their place, referred to as stand-ins. We called it judges doublers. They themselves said that they represented the government, because on one conference one of the judges said that he's here as a representative of the government, of the Polish government, the judge of the Polish Constitutional Tribunal. 3 other judges who had just been elected still are not adjudicating. And the new president of the Constitutional Tribunal or a person whom she had appointed as her substitute with no justification shuffled the panels of judges, especially considering the cases to their own like. For example, this concerned the last complaint lodged the National Council of Judiciary regarding to unconstitutionality of the provisions on the creation of new National Council of Judiciary. So, President of the Constitutional Tribunal decides out of the system who should get a particular case, which is important from the political point of view, yes, and changes the panels, yes. So at first we have one panel, and President of the Constitutional Tribunal decides that we should have another panel consisting from another judges. The new judges themselves examining the cases pertaining to lawfulness of their own appointments. They completely ignoring the principle of nemo iudex in casa sua. The President of Constitutional Tribunal expressed her own opinion on the constitutionality or legal acts on public television before the judgment. So we have a case in Constitutional Tribunal, and before the judgment, the President of actual Polish Constitutional Tribunal came to the television and said, my opinion, this case is. What can I say more about the Constitutional Tribunal for today? That it all results that the constitutional organs, such as Ombudsman, like National Council of Judiciary, the first President of the Supreme Court, withdraw their constitutional complaints from the Constitutional Tribunal, seeking that it became a facade institution. At present, nobody in their right mind would see the Constitutional Tribunal as a guardian of the constitutional, but rather as a highly politicized body. Another reform take the common courts. What changed? At first, changed the supervision of the Minister of Justice. In Polish system for today, the Ministry of Justice's General Prosecutor manages the finances of the common courts, supervises the courts, appoints the assessors, and also have a huge role in disciplinary proceedings by appointing the disciplinary prosecutors. He also can be a party in any criminal or civil procedure. So we might say that he has competences in any branch of law. What have been done with common courts more? I must say that they've changed the regulation according to the presidents of court. As many as 130 court presidents have been removed from their office before the end of their tenure. And new court presidents have been appointed by the Minister of Justice, because we have a new regulation which allows Minister of Justice remove all the presidents without any reason from their position for 6 months. Starting from this law came into the force. What is next? The next are disciplinary proceedings. The new solution expands the apparatus of prosecution of disciplinary proceedings against the judges and other members of legal profession under the control of Minister of Justice, granting him a significant influence on the disciplinary courts. The Minister of Justice has broad competences with respect to appointing disciplinary prosecutors and judges of disciplinary courts, as well as influencing of any disciplinary proceedings. They also create a special fast-track proceedings. During this track, the proceedings have to be complete within 25 hours to judge. We say that this special disciplinary proceedings is even worse in Polish system than to normal criminal proceedings, because in normal criminal proceedings the procedure have to take 48 hours. In our proceedings it is possible to take this procedure during the 25 hours, so less than in normal criminal proceeding. What is worth to underline, the Minister of Justice has obviously been granted also the full right to choose a disciplinary prosecutor for the judges of common courts, as well as 2 of his or her deputies based only on his underlined unlimited discretion power. So he can just choose, I want this guy as a